You're watching the legal breakdown. So, Glenn, you were at the arraignment today in Washington, D.C. Can you describe what you saw? And was there anything surprising or striking that stood out to you?
Well, let me just say the gravity of the moment when you see a former president of the United States being arraigned on charges that, in essence, he tried to overthrow our democracy. For openers, that was pretty dramatic. Now, I will say Donald Trump just sort of shuffled into court. The note I made to myself was he just kind of lumbered in. He didn't seem to be particularly engaged. One thing that I thought was really interesting, he apparently wouldn't even look at Jack Smith, whereas Jack Smith seemed to kind of focus on him like a laser beam. I think that maybe should tell us a little something about how this case is going to go. Otherwise, the judge did what judges will ordinarily do. She put him under oath because if he were to say something that was untrue, he could actually be charged with perjury or contempt of court. And then she informed him of his rights, including his right to remain silent, didn't have to make any statement. Any statement he wanted to make should go through his lawyer. And she arraigned him on the charges, which basically means she put him on notice of exactly what the four charges are that the grand jury indicted him on and the maximum punishment, which if you add it all up, comes to 55 years in prison if he's convicted of everything. So, I mean, the whole thing had a certain gravity to it when you realize just how historic, how unprecedented it is to have a former president of the United States being put on trial for trying to overthrow our democracy.
Now, aside from Donald Trump avoiding Jack Smith's glare, was there any interaction between these two?
None, none. Donald Trump was pretty disengaged. He talked with his counsel from time to time, but he really didn't engage anybody in the audience. Whereas Jack Smith, at the conclusion of the hearing, pretty much engaged everybody and anybody, seemed to be really comfortable in his surroundings. And, there was definitely, I think, a sense of, I hate to use the word defeat that I saw in Donald Trump, but it seems like maybe the realization of what he's facing is beginning to sink in. For gosh sakes, this is his third criminal indictment. And frankly, he is on the eve of being indicted a fourth time. You have to wonder when some of the Republican Party members are going to walk away from him.
Well, that was exactly the question I was going to ask is, do you feel like any of the gravity of this has dawned on him, or is he just deferring to the usual defiance that he usually displays while he's busy reveling in his victimhood? I mean, I'm sure you heard the post-arraignment little press conference that he gave where he basically just, cried victim a little bit and whined about what Washington, D.C. looks like and raised himself up as some hero.
Yeah, but his post-arraignment rant, which, hit all the typical notes, it didn't sound like he was exactly fired up. It didn't sound very compelling. Now, it's certainly more of the same. We've heard this nonsense over and over and over again. But listen, I think any thinking person who looks at the fact that grand jury after grand jury after grand jury, consisting of just average everyday citizens from the communities in which Donald Trump committed these crimes, have all concluded that the evidence supports that the man should be charged criminally. At some point, if you have the capacity to absorb information, it's got to be weighing on Donald Trump.
Yeah. Did the magistrate judge impose any restrictions on him? I know that prior to him going to this arraignment, we had been discussing the possibility of a gag order of some sort. What ended up happening on that front?
Yeah, so first of all, I was a little disappointed because the prosecutors didn't really raise any sort of consequential restrictions. I have said this before, Brian, you and I have talked about it, but Donald Trump is a danger to the community. I think by any standard, he is a danger to American society. He's a danger to our democracy. I maintain that he's probably the single most dangerous pretrial defendant in the criminal justice system today, federal, state, and local. So the law actually provides that if somebody is a danger to the community and the prosecutors have clear and convincing evidence, that's the evidentiary standard, showing he's a danger to the community, the law says he should be detained pending trial. Now, I don't pretend I thought prosecutors were going to make that request, but I will say the facts and the law support that request. I was hoping to see perhaps the prosecutors say, you know what, Judge, we would like to propose some narrowly tailored restrictions on Donald Trump's speech and on Donald Trump's posts to, prevent him from engaging in this reckless, dangerous, inflammatory rhetoric, lashing out at prosecutors and their family members, judges and their family members, witnesses, jurors, and yet there was no discussion. When they turned to the prosecutors and said, are there any conditions of release the prosecution is requesting? The prosecutor said, yes, and we have discussed that with the defense in advance, and I don't believe they are going to object. I believe they're in agreement. And essentially, the only consequential condition placed on him was that he is not permitted to have any contact with witnesses that he knows are fact witnesses unless that contact goes through counsel or is in the presence of counsel. But for that, a lot of the usual restrictions were placed on Donald Trump. You must appear at the next assigned court date. You must refrain from violating any laws, federal, state, and local. They did say the magistrate judge, this wasn't the permanent judge, Judge Chutkan, this was a magistrate judge handling this preliminary hearing, did say that you better refrain from anything that could be perceived as jury tampering, witness tampering. I thought that was a little bit unusual, a little bit out of the mainstream, and I think that is foreshadowing. Yeah. And in the event Donald Trump continues to post things or say things that arguably could run afoul of that admonition by the judge today, I think Judge Chutkan might have a little something to say about that.
Okay, yeah, so it's kind of like the first warning was already imposed on him by virtue of the magistrate judge releasing that little tidbit.
Exactly.
Glenn, did we learn anything new about the charges beyond what was released in the initial indictment?
We didn't learn anything new about the charges, but one curiosity I want to bring up, and this is a little bit of a deep dive, but I think it's important. Remember one of his lawyers, a guy named Evan Corcoran, actually a former colleague of mine that I handled a murder case with back in the day. He was the one who signed that false certification saying all of the Mar-a-Lago documents have been returned. Now, I'm mixing criminal cases for a minute, but I think this is important. And what happened after he signed that false certificate saying we returned all the documents to the federal government, that was found to be untrue, inaccurate, a lie. And so what Jack Smith did is he, figuratively grabbed that defense attorney, Evan Corcoran, by the scruff of the neck and put him in the grand jury. What he did was he litigated the issue of whether that attorney should still enjoy attorney-client privilege with Donald Trump or whether Donald Trump used his attorney in furtherance of a crime. The judge ruled he did use his attorney in furtherance of the crime, and Evan Corcoran was compelled to go into the grand jury and testify about, and in a very real sense, testify against Donald Trump, provide incriminating evidence. Guess who showed up in court today in tow with the Trump defense team? Evan Corcoran. He was the first one to come into the courtroom. He didn't sit at the defense counsel table proper, but he sat at the sort of backbench aligned with the defense counsel. Now, he wasn't announced as a defense attorney of record for Donald Trump, but I find it really interesting that one of his own lawyers, who was basically forced to flip against him and testify in the grand jury, is still with Donald Trump. I don't know if there's a saying, keep your friends close and your former attorneys who were forced to testify against you in the grand jury closer, but I think that was sort of a little observed fact or feature of today's hearing that I find really curious.
I also think it was Walt Nauta who Trump handed his umbrella to when he was re-entering the plane. So just another indication of how he's keeping these people who have a lot of power to flip on him, to cooperate with prosecutors, as close to him as he possibly can. And of course, these guys are perfectly happy to be doormats for him, obviously. Glenn, do you think that the unnamed co-conspirators are ultimately going to be charged, or are they just there because they need to be listed in service of the conspiracy charges against Trump?
100% they're going to be charged in a separate indictment, probably in a great big co-conspirator indictment. The reason I say that is when you read this 45-page indictment, maybe it was a coincidence that the 45th president has a 45-page indictment.
Yeah.
When you read it, it is clear that the 6 co-conspirators who aren't named but are identified in substance, I think we already know who 5 of the 6 are, and we have a pretty good idea who the 6th is. Jack Smith, in that indictment, made it plain they committed crimes. They were co-conspirators together with Donald Trump in his criminal determination to overturn the results of a presidential election. What no prosecutor would do is put that information in the public stream and then say, but you know what? I'm not going to charge any of them. The reason, in my opinion, Jack Smith didn't charge them in the indictment, although he listed them as co-conspirators, is because this case is built for speed. This thing is going to move 100 miles an hour in the direction of trial. And there are some things that the magistrate judge said today about what Judge Chutkan will be doing very soon in the weeks to come that I think prove that point.
And it's not going to be an issue that this is the case about those things, and yet those co-conspirators aren't being charged in this case. That's not going to be an issue. Like, we're not missing the boat here by virtue of not charging them in the case about what they're being charged for.
Not an issue. In fact, the more co-conspirators, the more co-defendants you pack into one indictment, the more cumbersome the trial becomes, and the more difficult it is to get it tried quickly. Because believe me, all of the various defense attorneys and defense teams will forever be coming up with scheduling conflicts and problems, and we have to push the trial date. We have to continue the trial. So the reason Jack Smith did it is it's not unusual to put uncharged co-conspirators in an indictment. It does not diminish the power of the proof against Donald Trump.
Now, do we have any indication as to when pretrial motions are going to begin, or even when the trial date is going to be set for?
Yeah, this is what I was referencing a minute ago, and I love this. The magistrate judge said, prosecution, in 7 days, you will file with the court a brief that sets out your proposed trial date and how long you think the government's case will last. Defense, 7 days after the government files its proposed trial date, you will file your proposed trial date. Then we will all reassemble, but you'll be in front of Judge Chutkan, the permanently assigned judge to this case, on August 28th, at which time Judge Chutkan will set a trial date.
Wow.
Now, that made the defense attorneys' heads explode, and they argued not once, not twice, but 3 times. Judge, we can't possibly file something with a proposed trial date until we get all the discovery from the prosecutors, blah, blah, blah. All 3 times, the magistrate judge said, you will be filing something with your proposed trial date 7 days after the government files its proposed trial date, and Judge Chutkan will be setting a trial. Brian, let me tell you, that's unusual. In cases like this, what happens is at the arraignment, the judge says, okay, we're going to set a status hearing for about 30 days from now, at which time we'll begin to discuss trial dates that might be amenable to both parties. No. All of this is not a cotillion. This is going to be a speedy trial. And I am so thrilled. I don't know if we've talked previously about my personal experience with Judge Chutkan when we used to try cases against one another when she was a public defender and I was a homicide prosecutor in DC. But, you know, she is no nonsense. She is tough as nails. She doesn't suffer fools or shenanigans. And I was so thrilled to hear the rule of law asserting itself aggressively, appropriately, but aggressively by Judge Chutkan making it clear there will be a trial date set 25 days from now. And I have a feeling she's going to set it, if I had to guess, for January, February. And this case will be long over, well in advance of the November 2024 election.
So Glenn, does that raise the possibility that Trump could actually be convicted and even sentenced possibly to prison time before the actual 2024 election?
Absolutely. And what are the consequences of that? Unfortunately, a convict, somebody who's convicted of felony crimes, is not prohibited from running for president. Somebody who is in prison convicted of felony crimes is not prohibited or disqualified from running for president. But here's the other thing it does. I think the voters should make a fully informed opinion about who they're casting their ballot for. And in the event Donald Trump is the Republican nominee for president, as crazy as that sounds, it will sure be nice for all of the voters, Republicans, Democrats, independents, to know whether they're casting their vote in the event they want to vote for Trump for a convicted felon, or they're casting their vote for a completely exonerated person at trial who was found guilty of all charges because he did nothing wrong. That's not going to be the verdict, I predict. But yeah, there are so many important reasons for purposes of our democracy that this trial must be concluded well in advance of the presidential election.
I've got to ask one more question. That is, what happens if Trump does win the election if he's in prison?
If he wins the election, he pardons himself.
And then, of course, it'll be up to the courts to litigate the legality of such a move.
It will. And there's one thing I'm pretty confident of, Brian. The Supreme Court will never endorse a presidential self-pardon, because that would actually put the president above the Supreme Court and out of reach of the Supreme Court, which, for reasons that we can discuss in the future. But I am confident that the Supreme Court will be motivated by self-preservation, that they will rule that a presidential self-pardon is unconstitutional.
Well, here's to hoping that it never gets that far. So with that said, obviously, we'll stay on top of all of this stuff as we look ahead to this major next date coming up of August 25th. So until that time, if you watching out there want to stay on top of legal news, make sure to subscribe. The links are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.